Je remercie Madame Geldich. I now give the floor to Mr. Mohammad Hillel. You have the floor, sir.
Thank you. Mr. President, distinguished members of the court, it is a privilege to appear before the court on behalf of the African Union. As indicated by the Legal Counsel of the African Union, I will cover the following issues. I will identify the internationally wrongful acts that are attributable to Israel and address the question of the legal status of Israel's occupation of the Palestinian territories. Second, I will address the question of whether there are circumstances precluding the wrongfulness of acts that are attributable to Israel. And third, I will outline the legal consequences arising out of these internationally wrongful acts. The point of departure for determining the legal status of Israel's occupation of the Palestinian territories is the question of title. Does Israel have title over the West Bank, Gaza, and East Jerusalem? The answer is unequivocally no. Given time constraints, I will only identify the main milestones of Palestine's history. Palestine was under Ottoman sovereignty, and it came under British belligerent occupation during World War I. Then, in 1922, Palestine was placed under a League of Nations mandate that provisionally recognized Palestine as an independent nation under British administration, after which Turkey renounced sovereignty over Palestine pursuant to the 1923 Treaty of Lausanne. This was followed in 1947 by the adoption of the Palestine Partition Plan, which was never implemented. And then in 1948, Britain withdrew from Palestine and Israel unilaterally declared independence, which was followed by armistice agreements in 1949 and the establishment of Egyptian control over Gaza and Jordanian control over East Jerusalem and the West Bank. And finally, in 1967, Israel launched an armed attack, as a result of which it occupied the West Bank, Gaza, and East Jerusalem. At no point in this process did Israel acquire title over these territories. Moreover, theories that support an alleged Israeli title over these territories, such as the claim that the legal status of Palestinian territories was indeterminate, or that there was a sovereign vacuum that Israel was entitled to fill, are entirely unfounded. Accordingly, since 1967, Israel has exercised belligerent occupation over the West Bank, Gaza, and East Jerusalem. The African Union also submits that Israel's 57-year occupation of the Palestinian territories is unlawful and must be brought to an end. This determination is based on three arguments. First, as the overwhelming majority of parties in these proceedings have argued, Israel's occupation is unlawful because it violates the prohibition on the acquisition of territory by force, which is a corollary of the prohibition on the use of force. This constitutes a violation of a peremptory rule of international law. The evidence on this point is incontrovertible. Pronouncements by Israel's political leaders and the conduct of Israel on the ground reflect an intention to perpetuate the occupation through acts that amount to de jure and de facto annexation of Palestinian territories. Israel's conduct in the current hostilities in Gaza also demonstrates its goal of entrenching its occupation of Gaza. Israel is reportedly planning to establish permanent buffer zones, maintain a long-term active military presence on the ground, and is striving to displace the population of Gaza to neighboring states. This conduct, which has been roundly denounced by the African Union, confirms Israel's intent to acquire and annex further Palestinian territory in Gaza. Second, also as the overwhelming majority of parties have argued, Israel's occupation is unlawful because it deprives the Palestinian people of their right to self-determination. It is uncontested that the Palestinians are a people that are entitled to exercise self-determination. It is also established that self-determination is a right that is exercised in relation to a specific territory, and that it is unlawful to disrupt the unity and integrity of the territory in relation to which the right to self-determination is exercised. In the present case, the territories on which the Palestinians are entitled to exercise self-determination are the West Bank, Gaza, and East Jerusalem, which constitute a single, indivisible territorial unit. Violating the right to self-determination also constitutes a violation of a peremptory rule of international law. Third, the cumulative effect of Israeli policies and practices that are associated with the occupation provides an additional basis on which to conclude that the occupation is, as a whole, unlawful. This is a point that deserves to be highlighted because it has been argued that violations of the law of belligerent occupation do not affect the legal status of the occupation. Specifically, the United States claimed, and I quote, that international law does not provide for an occupation itself to be rendered unlawful or void based either on its duration or on any violations of occupation law. This view is incorrect. The violations of international law committed by Israel in the occupied territories constitute continuing and composite breaches of international law. Specifically, Articles 14 and 15 of the ILC Articles on State Responsibility provide a basis for establishing that separate and distinct violations of the law of belligerent occupation can, when combined and viewed cumulatively, lead to the conclusion that the occupation as a whole is unlawful. Article 14.2 of the Articles on State Responsibility defines a continuing wrongful act as one that continues in time and remains not in conformity with an international obligation. According to the ILC, examples of a continuing wrongful act include, and I quote, the maintenance by force of colonial domination and unlawful occupation of part of the territory of another state. This confirms the relevance and applicability of this concept to the case of Palestine. Other examples of Israeli practices amounting to continuing breaches include settlements in the West Bank and East Jerusalem, the separation wall, the network of bypass roads, legislative acts purporting to annex portions of the Palestinian territories, and the exploitation of water resources in the West Bank. In addition, internationally wrongful acts that are attributable to Israel should be viewed as composite breaches of international law. As defined by Article 15 of the Articles on State Responsibility, composite acts are made up of a series of actions or omissions defined in aggregate as wrongful. This does not exclude the possibility that every single act in the series could be wrongful in accordance with another obligation. As the ILC explained, the concept of composite breaches is intended to address situations where the responsible entity, including the state, adopted a systematic policy or practice, and that is precisely why the concept of composite breaches is valuable in the present case. It captures the fact that Israel's conduct is not composed of random or isolated wrongful acts. Israel is pursuing a systematic policy that is designed to perpetuate its control of the Palestinian territories. For example, the establishment and expansion of Israeli settlements and the transfer of over 700,000 Israeli settlers to the occupied territories is wrongful under Article 49 of the Fourth Geneva Convention. Similarly, the construction of a bypass road is wrongful under Articles 46 and 52 of the 1907 Hague Regulations and Articles 49, 52, and 53 of the Fourth Geneva Convention. However, in addition to violating these specific rules of international law, the settlements, the bypass roads, and the separation wall and other practices are elements of an Israeli policy through which it is seeking to gain permanent control of the occupied territories, making it impossible to restore the status quo ante bellum. These Israeli practices, when viewed in their totality, make the occupation unlawful because they constitute composite wrongful acts that violate the prohibition on the use of force, the prohibition on the acquisition of territory by force, the prohibition on systematic racial discrimination, and the Palestinian people's inalienable right to self-determination. Mr. President, distinguished members of the court, I will now address the question of whether there are circumstances that preclude the wrongfulness of Israel's conduct. Specifically, I will argue that Israel cannot validly invoke the right to self-determination. The right to self-defense to justify its occupation of the Palestinian territories. In this regard, the historical record is unequivocal. Israel's occupation of the Palestinian territories was a result of an act of aggression that commenced on June 5, 1967. Moreover, it should be recalled that international law does not recognize a purported right of anticipatory, preemptive, or preventive self-defense. The terms of Article 51 of the Charter are unambiguous. The right to self-defense is triggered, quote, if an armed attack occurs, end quote. Indeed, the Organization of African Unity declared on numerous occasions that Israel's use of force in 1967 amounted to an act of aggression. It should also be recalled that in the Wall opinion, the court determined that Article 51 of the Charter has no relevance where the alleged threats invoked by Israel to justify its conduct originate from within, not from outside the occupied territories. And even if one were to assume arguendo that Israel may invoke the right to self-defense as a circumstance precluding wrongfulness, which it cannot, it is patently clear that self-defense cannot justify Israel's practices. Self-defense is a narrowly construed exception to the prohibition on the use of force. Israel's practices that are designed to perpetuate its occupation can never satisfy the requirements of necessity and proportionality. Furthermore, as several states have already affirmed in their pleadings, the exercise of self-defense can never provide a valid basis for acquiring title to territory that is occupied as a result of the exercise of the right to self-defense. Moreover, given that many of the internationally wrongful acts attributable to Israel are violations of rules of jus cogens, it is our submission that self-defense cannot be invoked in this context. Article 26 of the ILC Articles on State Responsibility and Article 18 of the ILC Conclusions on Identification and Legal Consequences of Peremptory Norms of General International Law are clear. Quote, where the responsibility of a state for a breach of a peremptory norm is invoked, the state against which the breach is invoked cannot excuse itself from responsibility by raising any circumstance that might ordinarily preclude its wrongfulness. In short, the African Union submits that Israel cannot invoke self-defense as a circumstance precluding wrongfulness. Finally, Mr. President, distinguished members of the court, I will turn to the question of the consequences arising from these internationally wrongful acts. The ILC Articles on State Responsibility affirm the customary principle that, quote, every internationally wrongful act entails the international responsibility of the responsible state. It is on this basis that in the Chagos opinion, after the court determined that the United Kingdom's continued administration of the Chagos archipelago constituted a wrongful act, it was held that the United Kingdom was under an obligation to bring an end to its administration of Chagos, quote, as rapidly as possible, thereby enabling Mauritius to complete the decolonization of its territory consistent with the right to self-determination. The same is required here. Israel must end its unlawful occupation of all the Palestinian territories as rapidly as possible in order to enable the Palestinian people to exercise their fundamental right of self-determination. This is the request that the majority of parties participating in these proceedings have made. The United Kingdom, however, is a notable outlier on this point. It argues that if the court were to address the status of the occupation and require Israel's withdrawal, that would undermine the Security Council's framework that is premised on reaching a two-state solution through a process of negotiations. The African Union does not agree. To condition the end of occupation on a negotiated settlement is to make the occupation permanent, given that the occupying power, Israel, refuses to negotiate on the basis of the two-state solution. And it has declared its will that it will never accept the establishment of a Palestinian state. Those states that purport to support the two-state solution ought to endorse calls for this court to unequivocally determine that Israel's occupation of the Palestinian territories is unlawful. This is especially necessary given the peremptory nature of the right to self-determination and the prohibition on the acquisition of territory by force. The modalities necessary to end the occupation as rapidly as possible could be decided under the supervision of the relevant organs of the United Nations. Israel's unlawful occupation of the Palestinian territories also gives rise to consequences for other states, including the customary legal obligations reflected in Article 41 of the Articles on State Responsibility, which are, 1, not to recognize any benefit accruing to Israel from the unlawful occupation, 2, not to lend aid or assistance to Israel that might further the occupation, and 3, to cooperate to end the unlawful occupation and to protect the right of self-determination of the Palestinian people. It is perplexing that the United States has challenged the customary status of Article 41. This long-established principle has been recognized by the court itself in the Wall Advisory Opinion and by the UN Security Council. It was even applied by the United States in 1932 in the context of the Japanese aggression against China in what was known as the Stimson Doctrine. Pursuant to this doctrine, the United States government declared that, quote, it cannot admit the legality of any situation de facto, nor does it intend to recognize any treaty or agreement that impairs the sovereignty, independence, or territorial integrity of China. The court should uphold this principle. In its written statement, the African Union offered various specific ways in which states may practically and meaningfully comply with these obligations of non-recognition, non-assistance, and cooperation. The African Union simply wishes to emphasize that occupation and self-determination cannot exist at the same place and the same time. If occupation is illegal, it must be ended to permit the recognition of self-determination. In closing, Mr. President, members of the court, the African Union reiterates its call to end Israel's occupation of the Palestinian territories. The injustice being wrought against the people of Gaza as we convene here in the Great Hall of Justice makes it imperative to end Israel's impunity and hold it accountable to the rule of law. The court of history may very well judge the credibility of international law on the basis of the outcome of these proceedings. The international community has let down the Palestinian people, but the African Union has faith that in this court, justice will prevail. The betrayal of the sacred trust that is the self-determination of the Palestinian people is an enduring injustice that pleads to be remedied. It is the only path towards ensuring a future of security, stability, peace, and prosperity for the peoples of a troubled region. Thank you for your attention.
I thank the delegation of the African Union for its presentation. The court will meet again this afternoon at 3 p.m. to hear Spain, Fiji, and the Maldives. The sitting is adjourned.